end up having to work.
All right, well then, let me go through this with you also. This is a landlord-tenant proceeding. In your case, it's a demand for non-payment of rent. If you can and afford to hire an attorney, if you wish to have one, a legal aid attorney could be available to assist you. You have a right to have the case heard here in St. Joseph County where the property is located. Your landlord has asked you to be evicted in Mr. Whitson's case because they want you to move. In Ms. Talbert's case, they want you to either pay the rent or move. In the case of non-payment of rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated agency, which is Community Action Agency, Housing Assessment and Resource Agency, which in our case is Neighborhoods, Inc., or federal help for homeless veterans if you're available and eligible for veteran services. We sent that information to you with the summons that you received. You do not need a judgment against you to receive help from the places listed above, despite what the DHS might tell you. A copy of the summons and complaint are sufficient, and you've already received that. All right, no grooming on live feed.
He had something on his face.
Reach an agreement outside of court by going through mediation. If both parties are interested, we can pursue that and I can help set it up. You may be able to reach an agreement with the landlord. That means the case would get dismissed through a conditional order of dismissal. If so, the court will assist you in preparing that form or locating it. So, Mr. Whitson, at this point, they're not asking for rent anymore. They want you to move off this railroad street property in Sturgis. They allege that you failed to maintain the property and they want you to move. Now, Mr. Moore, you don't live there. You're simply a co-signer on the lease.
I'm not. I didn't sign anything, Your Honor.
But you don't live there?
No, I never lived there. And I don't even know why my name, I haven't signed anything, Your Honor.
Why is he here?
Because
I have no idea.
Well, Ms. Richmond, why is Jack Moore here?
Because he was a co-signer. He was also on the lease.
No, I was not. I was on no.
Just let me look.
He didn't.
Bed bug is Whitson. Carbon monoxide is Whitson. I don't see Jack Moore's signature on anything.
It's not.
He is on the lease, Dwayne Whitson / Jack Moore.
No.
But he did sign the lease. All right, well, Mr. Moore, stick with me.
We weren't here at the time, so Lydia did it.
Anyway, so you don't have a dog in this fight, but Mr. Whitson, they want you to move. What's your position?
That's no problem, Your Honor. I mean, I failed to maintain the property because of some trash and stuff, but I was recovering from double pneumonia at the time, but I did my best to pay the rent. And I work for Jack Moore, and work's been slow and so forth, but I sold my truck, as you know, last time to catch the rent up and cut it up and gave them an extra $1,000 towards May's rent at that time, you know, that I could. And then I went to pay rent and on the 5th, I believe, of June, and Ms. Richmond Terry said that she couldn't take it because they were evicting me. So that was the first time I really heard of it. But I mean, that's no problem. I'm not trying to stay here, you know, past my work. I just need to.
How soon can you vacate?
I mean, what I would like to do is offer the Richmonds. When I moved here, guys, Larry and stuff, last year, I bought all new stainless steel appliances and so forth, stove, fridge, washer and dryer, all Whirlpool, and microwave. And if I could have till like August 1st to vacate, I'll go, no problem. And you guys can keep that. Maybe it'll help you rent the place, furnished with stove and
so
everything.
You would agree to vacate on August 1st and leave all the appliances?
Yes.
You talk. Yeah.
That'll give me time to, get money and I can find an apartment or something. No hard feelings, no, didn't.
Well, Mr. and Mrs. Richmond, that would be only an additional 13 days. We have to adjourn this to the 7th of July, and then he'd get 10 days from that. So he'd get until July 17th. So by his proposal, he agrees to leave by, we'll call it July 31st,
Okay.
out by August 1st, and leave the appliances. So is that agreeable to you, Mr. Whitson?
Yes,
Mr. and Mrs. Richmond, is that agreeable to you?
Yes.
Yes.
So we
I
got to
got the sense from the last case that you guys had a fairly decent landlord-tenant relationship, but at this point, it's just what it is. So I'm going to show by consent, defendant agrees to vacate by July 31st. We'll leave all appliances in place.
Do we have to come back to court then?
No,
Okay.
you have until July 7th to appeal this. Mr. Whitson, we've just made an agreement
Mhm.
for a consent judgment. You don't have a lawyer. So you do have the right under the law, which is MCR 4.201J, to change your mind. If you didn't understand or disagreed with what we just did, you can tell the court within 3 business days. We'd have to schedule a hearing regarding that. Otherwise, I'm going to show a consent order that you'll be out by July 31st as opposed to July 7th or 17th. And if you vacate at that time, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. Then you will also leave all the appliances in place.
Yep.
And the tenancy will be over. They're not at this point asking for any money damages. They're just asking for possession. If we're going to have a hearing regarding money damages, that will be at a later date. Do you agree with those terms and conditions?
Yes, Your Honor.
Do you have any questions?
No, I don't think so.
All right. You guys have good contact with each other. Stay in contact. Let them know what your intentions are. As I said, when you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. And Mr. Moore, this really doesn't have any effect on you. You don't live there. You didn't appear to sign the lease. And he's going to vacate, and you can just go on with your life as you have.
Okay, thank you, sir.
All right, you're good to go. Thank you.
Bye-bye.
Bye. All right, Mr. Whitson, you're good to go.
Okay, thank you, Your Honor. Thank you, Larry and Terry.
Oh, you're
All right,
welcome. Thank you.
Yes.
That sounds like a pretty good agreement. See how appliances are, and he gets a little extra time, and he doesn't have to move all that. And all you're giving up is 13 extra days, 14 extra days. All right, Ms. Talbert, let's talk to you. We went through the advice of rights. This is Terry and Larry Richmond versus Wayne and Leslie Talbert. Wayne is not here. Terry and Larry Richmond are here. Ms. Talbert, this case is a little different. The last case, they just wanted the guy to move out. In your case, they want you to pay the rent. And if you can't pay the rent, then you have to move. But Ms. Richmond, what's the current arrearage?
Okay, she paid some money. There was money in the office today, so her rent is only $487.02. and court costs were $199.25 for a total of $686.27 through 7/3.
All right, this is, I think, week to week through Thursdays, but you just made a payment.
Yeah.
So you're really not that far behind. Miss Talbert, do you agree with that?
Yes.
All right, well, the law says you're entitled to 1 7-day adjournment, and then you'd get 10 additional days from that day to pay. So let's take a look at where we are in 7 days. That would be July the 7th at 2:10. Does that work for you?
Paid a six. I forgot the amount. What was the amount again? I'm sorry.
The amount is $686.27.
Okay.
Now, it's gonna change, because you're gonna owe another, it's $250 per week.
Yes.
Yep. And yep.
All right, so there'll be another $250 due by July 7th. But this is through July 3rd. You owe $487.02, $199.25 in costs. I'm not gonna default Wayne because he's at work. You heard the other case, the people were bad. They didn't have enough ambition to get up to appear at their eviction hearing. But people are at work, they're trying to earn money to pay the rent, so I don't do a default.
Okay.
Ms. Talbert, let me ask just for a minute, how are you guys doing?
We're doing okay. We just figured that we'd be in a better place financially, but I had to end up having surgery, which kind of put us back. I had
I don't
surgery
want to
on.
get into your personal business, but as you know, we've
Okay.
had some cases and we got through them, and I just want to make sure you're doing okay.
Yes, sir.
Um, All right, we'll revisit this next Monday. Now, if you've paid Monday the 7th, excuse me, not next Monday. If you paid everything, you don't even need to appear. So if you can pay everything by that date, then you'll just
July
be back.
7th.
If you can't, then we'll discuss it further and see what the arrearage is. But as I indicated, by the time we come to court, there'll be another week's rent due.
Okay.
And
All right.
what time was court on the 7th?
2:10.
2:10. Okay.
All right. Anything else we need to do here?
Nope, I don't think so. Thank you.
Thanks, Your Honor.
All right. Good luck to you. I'll see you guys in 10 days.
Okay.
Okay,
Bye-bye.
bye, Leslie.
Bye-bye.
All right. All right, Miss Richmond, you guys can go out and mow your lawn or whatever you got going on today. All right, now we've got 9:40, and we had a number of Riverside Townhouses cases which are dismissed. So let me address those because nobody's here. So that certainly helps us catch up. Riverside Townhouses versus Brian. That's not it. Keithia Longs, which is file 2512739. That's set for 9:40. That's dismissed. Not a conditional order of dismissal, just a dismissal without prejudice. Riverside Townhouses versus Kayla Rice. 251240. This is also a dismissal without prejudice. So neither party is here on any of those cases. Riverside Townhouses versus Stephen Severide, I think it is, not like Eric Severide, but I think that's how it's said. When I was a kid, my dad would watch Walter Cronkite News every night, like everybody did. And Eric Severide would do commentary on there, very eloquent. And as a little kid, I didn't understand what he was talking about, but I liked the sound of his voice. And I liked to listen to him. And then as I got a little older, one day I realized I actually understood what he was talking about. All right, so that catches us up until our next matter, which is set for 9:55, which is 7 minutes from now. We have a Village Manor case. We have a new law firm on behalf of Village Manor. It's the Gromer and Burkhart law firm of Bingham Farms. They'd had different attorneys over the years, Mr. Hass, Levine, Jarrett Levine, and some other firms, but no, this is a new firm. Anyway, they resolved all three of their Riverside Townhouses cases. So that takes us to 9:55. We got lots of rivers here in St. Joseph County. We have more navigable streams and rivers than any county in the state. So we have lots of stuff called river this or river that. So once we finish Riverside Townhouses, we're going to have a Riverside Estates, which is not much of an estate, but it's a mobile home park located on Withers Road, which we're going to deal with. Then we have a damage hearing for money damages in a case set at 11. So we'll see how we do. So we have three more landlord-tenant cases, Meg, and you've got an appearance in one of them. And then we have a damage hearing.
It's funny, a little bit funny that you say that about the name of the complexes.
Yeah.
Got myself in a little hot water with support staff yesterday. Or Monday through yesterday, I asked one of our assistants to do a license search, and I actually did ask her to do three Freedom of Information Act requests, and I put the wrong name. Like I transposed Riverside, River Estates, Manor, Acres.
We've got Edgewater, we've got Waterfront, we've got Bentwaters, a lot of water.
And I have no idea how I ended up taking two different, like what I came up with wasn't actually an entity at all. I was just moving too quick, but luckily she caught it. But I felt kind of bad because she did a lot of work.
Yes, we're good luck for our administrative staff. They keep us all on track. All right, this matter is set for 9:55. It is 9:50.
Judge, was that Kramer and Burkhart firm on Village Manor? Were they also on the Riverside town?
Yes, they were, same firm.
Okay, thank you.
As we've discussed, Zoom has altered the landscape for landlord-tenant cases. In my early career, each complex had their own local attorney, and it was a good spread of the legal work. Different attorneys would maybe represent one or two complexes in their neighborhood. They were easy to get to. The managers could go to their office. Now, certainly the largest institutional complexes have gone with large landlord-tenant firms. That's Meg's disappearance.
Yep.
All right, those are good to go.
Okay.
Thanks for those 3 dismissals. They caught me up.
Yeah, thank you.
I missed the local council.
Yes, Debbie Davis did Enchanted Glen, Joe Hass did Riverside Townhouses, Andy did several in Sturgis, Matt Davidson did some in Three Rivers, Debbie Krebs did Walnut Meadows. I think Christine Yancey did several places. Lance Thornton did some. Good morning. Welcome to Centerville.
Morning, Your Honor.
We're going to let the clock tick for a minute, see whether your defendant shows up. This property was served by attachment.
You're correct.
All right, I have trouble keeping track of your manager, Ms. Cousineau, but she's apparently now at Village Manor. Good morning.
Good morning.
And Judge, I believe we did a second mailing on this one also.
All right, let's take a look. Yes, you did.
Okay.
I've got some 10 o'clock stuff too. I forgot about that. How do you say your name? Gowdy?
Gowdy, yes.
A minute. Title of this case is Village Manor Apartments versus Richard Wilcox or any other occupants at apartment A1. Won't give the number, Laura Court. Mr. Jeff Gowdy is here for the Burkhart Law Firm. We haven't dealt with your firm. You've apparently picked up some new clients here. You had 3 Riverside cases this morning that were resolved. And now this Village Manor. Just to let you know, we try to start on time.
Okay.
So if we tell you your hearing's at 9:10, I try to start at 9:10.
That's
Because you
very
guys
good.
got to be a lot of different places at the same time. And so we try to stick to our schedule so you know when you'll be in and when you'll be out. At least that's our hope. So today we're pretty much on schedule. We can always get a clinker of a case that sends us sideways, but all right, well, let's talk about this. Mr. Gowdy or Ms. Cousineau, what's the arrearage here?
Right now, the rent or retained possession is $969. Plaintiff
That's through June?
that is through June. And plaintiff had costs of $200.50. Total judgment plaintiff is requesting is $1,169.50.
Well, let's see if they're here. Hi, sorry to keep bugging you. I'm looking for a Richard Wilcox. All right. It's not the guy that owns Wilcox newspapers. Ms. Cousineau, as far as you know, are they still there?
No.
Okay,
So he passed away in February.
Oh. Is anybody in there?
No.
All right, well, sometimes, as you know, they'll leave squatters behind or others. So we have a second mailing. I'm just gonna go with the 10 days. I don't have a judgment here, Mr. Gowdy. It's often helpful to have the judgment right at the time of the proceedings. All right. He's not here because he's deceased. Is property still in the premises?
His property is, yes.
Does he have family?
Nobody that wants to take possession of it.
Well, Mr. Gowdy, let me give you our email address so you can put it in your library. It's 3B Civil at St. Joseph County, COUNTY, MI.gov. And if you email me a possession judgment, I will order that this property be vacated by July 7th.
That works for plaintiff. We will get that judgment over to the court this morning.
All right, I look forward to working with you. Like I say, we try to do things on a timely manner. I don't know if we always do it right, but we try to do it the same way every time so people know what to expect. We have a second mailing here. Yeah, this will be a matter of the complex having to clear this property out and prepare for the next renter. All right, anything to add here?
No, Judge, nothing further from plaintiff.
All right, I'll await that judgment. I'll sign it this morning. And thank you. I'll see you next time.
Thank you, Judge. Have a good day.
Thank you.
Thank you.